Aurora.
Well, thank you, Mr. Speaker. I rise tonight, obviously, to comment on Bill C-14. Before beginning, I want to commend all members of this House for so far treating this debate with the sensitivity it warrants. This is, without doubt, an issue that evokes much passion on both sides of the issue. This debate, at its essence, pits the sanctity of life against the inherent autonomy of the individual. I think it may be a worthwhile exercise to go back in time, not just a little bit, but back a few decades, so we can attempt to put this current debate into some legal context. The common law crimes of attempting suicide and of assisting suicide were codified in Canada when Parliament enacted the Criminal Code in 1892. 80 years later, in 1972, this House repealed the offence of attempting suicide from the Criminal Code, based in part on the argument that a legal deterrent was unnecessary in those circumstances. However, the prohibition on assisting suicide remained. This prohibition is found currently in Section 241 of the Criminal Code. This, in my opinion, is the fundamental shortcoming of our current law. You see, currently, able-bodied Canadians can take their own lives without any legal consequences. Those who physically cannot are currently discriminated against from doing so. This brings us to Carter, a unanimous decision of the Supreme Court of Canada, which overturned the 1993 case of Rodriguez. Carter holds that, among other things, the Criminal Code prohibition against assistance in dying found in Section 241 is unconstitutional on the grounds that denying disabled people the right to assisted suicide is contrary to the Charter of Rights and Freedoms. The current legislative prohibition found in the Criminal Code was held to be overbroad in that it prohibited physician-assisted death for a competent adult person who, 1, clearly consents to the termination of life, and 2, has a grievous and irremediable medical condition, including an illness, disease, or disability that causes enduring suffering that is intolerable to the individual in the circumstances of his or her condition. This leads us to where we are today. The court decision requires strict limits that are scrupulously monitored. This government is proposing a framework that considers different interests, including personal autonomy toward the end of one's life, the protection of vulnerable persons, and conscience rights. All values that are deeply important to Canadians across this country. The debate regarding medical assistance in dying is important to each and every one of us for different and for deeply personal reasons in many cases. For all Canadians, this is a difficult and profoundly sensitive issue, tied to their life experiences and personal beliefs. I have heard many of my own constituents share with me their opinions on this bill, some of whom face difficult and sometimes unimaginable health challenges. Just today, I received an email from a woman in my riding suffering from a slow-moving form of ALS. Gradually, this horrible disease has taken her voluntary muscle control, making it difficult for her to sign her own name and to speak and to even form the most basic sentences. In her own words to me, she describes the situation as thus: our hearts continue to pump. We are aware of everything happening to us and around us, but become unable to do the simplest things for ourselves. We cannot predict our lifespan. She urged this House, through me, to reconsider the issue of advance directives. This is one Canadian who will be directly impacted by Bill C-14, one Canadian of many. You may ask why I relay this story. and that is because Bill C-14 clearly states that a requirement for assisted dying must be that a natural death is within the reasonably foreseeable future. And for many Canadians suffering and looking towards a future of only further pain and suffering, there is no clear distinguishable path to death. But this should not diminish their choices. For some, without this choice in the future, it can feel like a loss of comfort, a loss of safety, and a loss of autonomy. Additionally, this past weekend, I had the opportunity to sit with a few of my fellow members of Parliament from York Region to listen to important concerns and questions relating to Bill C-14. With an open mic, this event not only provided the opportunity for the participants to express their views and opinions on medically assisted dying, but also allowed me a great opportunity to meet and discuss on a more personal level with the people in my community that will be directly affected by the results of this debate. While these discussions are important, it is equally important that a person does not come to end-of-life decisions lightly. Oftentimes, the decision follows years of personal deliberation and what I can only imagine would be the most difficult conversations with family members and those closest to them. For these reasons, and many others, Bill C-14 cannot and should not be taken lightly. And while there will always be those who believe this bill does not go far enough, others believe it goes too far. The Supreme Court of Canada unanimously decided that Canadians suffering intolerably have the right to request assistance to end their suffering. This bill respects that decision. However, I would encourage all members to engage with their constituents on this important matter and bring that informed advice to committee. Medical assistance in dying represents a significant change in the Canadian medical landscape, and this government has conducted consultations with many experts. Physicians have indicated that they would be most comfortable providing this option to patients approaching death as another option alongside palliative care, withdrawal of treatment, or palliative sedation. These options are all individually important and are woven into this bill to ensure that patients are served and equally protected, as well to limit any risks to physicians. As this government engages with the provinces and territories to support the development of a pan-Canadian monitoring system to collect and analyze data, monitor trends, and publicly report on medical assistance in dying, I ask that we all take time to consult with our constituents. While I am open to this government's Bill C-14 and will support it to move it to committee, I do feel some amendments may be necessary. We as legislators aren't doing our jobs if we aren't open to continually hearing from Canadians and engaging in meaningful consultations and dialogue, especially on an issue as important and fundamental as this one. I urge all members to also support this bill. Thank you, Mr. Speaker, for allowing me to rise to speak on such an important topic and share my perspective. Thank you.
In comments, the Honourable